Welcome to the Tenant Law Podcast. I am Michelle Itkowitz, and today is a listener question episode. Today we answer the question of Damien from Williamsburg, who asks, and these are Damien's words, I only cleaned this up a little bit. My landlord is suing to evict me from my rent-stabilized apartment for non-primary residence. But I swear I live in the apartment. My travels and absence from the apartment are directly related to the illness of my mother, who lives outside of New York City, whom I needed to assist until her passing in 2023. I was unaware of the legal requirement of residing in a rent-stabilized apartment for at least 183 days a year. I wish I knew about this requirement before, but English is not my first language. I have a lawyer, but I would like to know if I am going to lose my apartment because I was gone for more than 183 days this year. First, as always, let's set the stage with some context. A rent-stabilized apartment is a great thing to have. It can be a forever home. It's very difficult for a landlord to evict a tenant from a rent-stabilized apartment. But one of the requirements for a tenant to remain rent-stabilized is that the tenant must live in the apartment as their primary residence. Primary residence. That's pursuant to Rent Stabilization Code 2524.4. Therefore, one of the most common grounds upon which a landlord can attempt to evict a rent-stabilized tenant is that the tenant allegedly does not occupy the apartment as their primary residence. So to answer Damien's question, we essentially need to answer the question, what does primary residence mean in the rent stabilization context? Okay, so to answer Damien's question, we're going to start with the relevant statute. We always start with the statute if there is one. In this case, it's Rent Stabilization Code 2520.6. And the important thing that this statute tells us about non-primary residence is that there's no single factor that shall be solely determinative of whether or not an apartment is a tenant's primary residence. That in and of itself is the most important thing. There's no one single factor. There's no magic bullet. The statute, however, suggests things that a court could look at. It suggests 4 different types of evidence. I'm going to go over 3 here today. One is public documents such as tax returns, motor vehicle registration, driver's license, or other documents filed with a public agency. If those documents remain associated with the apartment, it's more likely that that apartment is your primary residence. But that alone is not going to save you if everything else indicates you live elsewhere. Another category of proof courts can look to, according to this statute, is how much you're in the apartment. So that's where we get they refer to occupancy of the housing accommodation for an aggregate of less than 183 days in the most recent calendar year. Where are they getting 183? Well, that's half of 365. So if you're gone more than half the year, well, that tends to indicate that maybe you don't really live there. Maybe the apartment isn't your primary residence. But again, then the question is going to be, well, why aren't you there? But that's what we get from case law, and we're going to talk about that in a minute. Another category of proof that the statute suggests we look at is whether or not the apartment was sublet. If you sublet the apartment, well, it's more likely that the apartment is not your primary residence because, as we saw actually in the last episode of the Tenant Law Podcast, we were discussing what was the difference between having a roommate and subletting your apartment. And we discussed that when you sublet, it's an interest in real property that you're really giving over the whole apartment to your subtenant who has exclusive use of the apartment. And that means exclusive even against you, the tenant. So you as the tenant can't just come right back in. So if you can't come right back in, that makes it feel very much less like it's your primary residence. So these are factors suggested by the actual statute on the non-primary residence topic, but case law gives us many other things. So let's look at some cases. We are going to look at a case that I had, and we are going to look at an appellate case in Damien's jurisdiction. First, I had a case very much like Damien's at one point where I won on behalf of the tenant. The tenant got to keep the apartment. The court found that the apartment was the tenant's primary residence. My tenant client was a tenured professor at a New York City university, one of the colleges here in New York. And he was tenured. So his wife, unfortunately, was very ill. She had cancer. And their son was an oncologist in Texas. So the wife went to Texas to be treated and to be close to her son near what turned out to be the end of her life. And the tenant went to Texas and joined them. Now, he was not gone for 183 days. He was gone for 2 years. That tenant was gone for 2 years, and we still managed to save the apartment, and the court found it was his primary residence. Why? Because as soon as his wife passed away, he came right back to New York, and he picked up where he left off. He was tenured, so his job was still there. So he started teaching courses once again here in New York. And he never sublet the apartment, and the court very much took note of that. Let's look at an appellate case from your jurisdiction, Damien, the Second Department. In 2004, Lance Realty versus Pfefferma. I put a link to this case in the show notes, and I'm going to read from the case because it does a good job of explaining it. The evidence, fairly interpreted, supports the civil court's determination that the subject rent-stabilized apartment is tenant's primary residence. Tenant maintained bank, brokerage, and utility accounts at the New York City address, which he also used for tax returns and voting. Tenant's furnishings and personal possessions are in the New York City apartment. While tenant acknowledged spending considerable time in Florida helping to care for his elderly mother aged 98, that circumstance does not, in and of itself, mandate a finding of non-primary residence, particularly since tenant had no ownership interest in his mother's Florida apartment and slept on the sofa bed in the living room during his stays there. It is so interesting how these cases turn on these little details. Here, the court very much took note of the fact that this tenant didn't even have a bedroom in his mother's Florida apartment. He didn't get another apartment for himself. He didn't even have a bedroom. He slept on her sofa. So no matter how long he was there was a temporary feel to it. It wasn't, the apartment continued to be his primary residence. It's where he intended to return to. So now let's do this. Let's imagine for a minute that these cases that I just talked about, let's change some details and see how a court might look at them differently if a few things were different. So what if the relative who had passed away in these cases, what if the tenant had remained in Texas or in Florida for another year after the tenant died before they came back? Well, that starts to feel different because you're not away to take care of a sick relative if the sick relative is out of the picture. What if these tenants, while they were in these other states, had joined a religious organization, a church or a mosque or a synagogue, whatever? They joined up with a religious organization. Now, you could see how somebody could do that, maybe for comfort, especially when a loved one's dying. But what if they took on a leadership role in their church? And it's something where, they took on a lot of responsibilities that would tend to be something that you would take on if you were a permanent member of a community. Something like that. I've had cases where things like that are considered by the judge. What if the tenant in either of these cases had posted on social media, and I know this is less possible in the 2004 case, but pretend the case was today. Let's say either of these tenants posted on social media something like, wow, I am so glad to be out in New York City. I'm so glad I live in Texas. I'm so glad I live in Florida. I understand why everybody's moving to Florida. I'm so happy that I moved. So if you put something like that on social media, it tends to create an assumption that, well, you don't live in New York anymore. So I like to say this: non-primary residence cases are like snowflakes. No two are alike. Everyone is different and everyone is highly fact specific based on people's very different lives. So, Damien, your job is to help your lawyer paint a picture for the judge of why the apartment is the place you intended to return, the place that you're still physically connected to, the place that you consider your home, and that's what you have to do. And this all leads to a very interesting tenant takeaway. But first, housekeeping. Let's get that out of the way. This is not legal advice. I'm not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it is legal advertising, it is terrible because I'm asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Email us with your questions to answer on the pod. If you like our work, give us those 5 stars and put the podcast on your socials. Damien, I hope this information has helped you, and it's time for the tenant takeaway. Tenant takeaway time. So today we discuss several things that courts consider when trying to determine whether a tenant occupies their rent-stabilized apartment as their primary residence. What did we talk about? We talked about government documents, how much time you were away, whether or not you sublet the apartment, why were you gone, what is going on with your job? Is your job still in New York? What is going on with your possessions? Are they still in the apartment? And social media posts. But there are so many other factors considered by courts in these cases. Again, these matters are very holistic and fact determinative. So I have identified about 32 different categories of proof that courts look at, and I've compiled them in a free 45-page booklet about this topic that I have posted on the Tenant Law Podcast website entitled How to Protect Your Rent-Stabilized Apartment from a Non-Primary Residence Claim. And I will put a link in the show notes to that book. That book is really, it was intended to be a preventative guide. It wasn't supposed to have anything to do with court. It's not a how to win a case in court book. It's how to prevent even getting to a non-primary residence claim. Still, Damien, it probably wouldn't be a terrible thing for you to look at this point. Which brings me to another point I want to make. If you're a lawyer out there listening to me, a few of you have contacted me. Thank you for listening. This book that I refer to, while it's a terrific resource for tenants to try to understand this non-primary residence topic, it's not a great resource for attorneys. The way I communicate to the general public is very, very different than how I would communicate to other lawyers. I teach tons of accredited continuing legal education, so you can Google me and take one of those classes if you're so inclined. But all the resources offered in relation to the Tenant Law Podcast are very much for non-lawyers. So the takeaway today really is that these are very holistic cases. You have to look at the overall picture. So you should discuss everything that was going on in your life, Damien, with your lawyer. And I really hope this helps. I understand these are very hard times. People shouldn't have to choose between taking care of a sick relative and losing their forever home. So I really do wish you luck. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.